All right. So today we're going to discuss one of the most foundational concepts in all of criminal law. And that's the two essential elements that are required for a crime. And honestly, this is where students begin kind of realizing criminal law is more intellectually complicated than just simply asking, did someone do something wrong? Remember that in criminal law, it's not usually enough to just prove that something bad happened or even that, someone physically committed an act. But instead, criminal liability often depends on two separate things occurring together. You have your criminal act, and then you have a criminal mental state. And in Latin, those concepts are called mens rea and actus reus. So, nearly every criminal law issue that you're going to encounter kind of moving forward is going to connect back to both of these because criminal law is not concerned with what happened. It's also concerned with what was the defendant thinking? What did they intend? What risk did they understand? What actions did they voluntarily choose? And this is important because the legal system generally distinguishes between accidents and mistakes and reckless behavior, negligence, and even intentional wrongdoing. Okay, so throughout this lecture, I want you to kind of think about one major theme. Should society punish people for bad outcomes alone, or should punishment depend on a person's mental state and their level of intent? Honestly, that question is part of what, really kind of sits at the center of criminal law, which we're going to talk about more. Let's begin with mens rea. So mens rea is translated as guilty mind. And that phrase sounds dramatic, but the idea itself is actually fairly logical. So most criminal laws require some level of criminal intent before criminal liability attaches. So in other words, the legal system generally wants to know not only what someone did, but what they were thinking at the time when they did it. Okay. And that makes sense intuitively. So let's imagine two different scenarios. In the first one, you have someone who, say, poisons another person in order to kill them, right? But in the second, someone accidentally gives another person maybe the wrong medication because two prescription bottles looked nearly identical. Now, both situations can result in death, but society views those two situations differently because of that mental state and how dramatically they differ. That's the distinction in mens rea, okay? Historically, criminal law kind of strongly embraced this idea that there should generally be no crime without a guilty mind. And that concept developed heavily through common law traditions. And the reasoning was that criminal punishment should generally just target morally blameworthy conduct rather than pure accidents. Now, this doesn't mean that every crime requires evil intent, because there are exceptions involving things like recklessness or negligence or even strict liability offenses. But generally speaking, criminal law heavily focuses on mental state. Okay? So, criminal statutes, they're not always perfectly consistent regarding those intent requirements either, because different jurisdictions define mental states differently. So courts can interpret those statutes differently as well. And then you have legislatures that sometimes draft laws very ambiguously. So the lack of uniformity becomes one reason that criminal law analysis becomes extremely complicated and exhausting. Now, one of the first major categories of intent is specific intent. And specific intent means that the defendant intended to not only commit the act itself, but they also intended that precise criminal result, okay? That is very focused and purposeful form of intent. So, for example, someone carefully plans to burn down a building in order to collect the insurance money. That involves more than just simply starting a fire. Like, you have to intend destruction, fraud, and even the resulting, financial benefit that comes from it, right? But compare that to a situation where someone recklessly starts a fire and it's because they're intoxicated and they don't specifically intend that destruction. The physical outcome may still involve fire damage, but that mental state still differs significantly. And honestly, criminal law cares tremendously about those distinctions. Specific intent crimes often require proof that the defendant's conscious objective was to produce a particular result. Now, that becomes especially important regarding defenses because certain defenses can reduce liability if the defendant lacked the specific intent for the conviction. Okay. Um, Actually, a really good example of that is going to be burglary, where you have the general intent of entering the home, but there has to be the specific intent of committing a felony once you're inside. So they would have to prove both the general intent and the specific intent. And this might be a way to have a defense come up that, reduces that liability for that specific intent portion as well. This slide also talks about scienter. And scienter refers to the knowledge of wrongdoing or the knowledge of a specific fact. And this becomes important in crimes where awareness itself matters. So, like if you receive stolen property, right, that generally requires knowledge that the property was stolen. So, like if someone purchases a laptop from a neighbor during a garage sale and that buyer has, genuinely no reason to believe that laptop was stolen, then criminal liability most likely will not exist because the scienter is missing. Now, in comparison, let's say that you purchase, really expensive, gaming computer or somebody who's selling it very suspiciously from their, trunk of their car. And of course, they're selling it for the low price of $25 and serial numbers are scratched off, things like that. At that point, you have either knowledge or you have deliberate ignorance. Okay. And it becomes easier to infer, right? And honestly, many criminal law cases do involve proving what someone knew or what they reasonably should have known. Because defendants rarely announce, yeah, I knew this was illegal. So prosecutors often rely on the totality of the circumstances in order to establish the intent and the knowledge indirectly. Now, general intent is different from specific intent. General intent usually requires proof that the defendant intended to perform the actual act itself, even if they didn't specifically intend for the resulting harm. Okay. So, for example, someone, let's say that they punch another person during an argument. They may not have intended some sort of severe injury, but they intentionally committed that physical act, right? So that intentional conduct can satisfy those general intent requirements. All right. And this is something that a lot of people have trouble kind of distinguishing, where you have specific intent from general intent. And one way is to think about it like this. Specific intent focuses heavily on the intended result, whereas general intent focuses more broadly on intentionally, engaging in some sort of, prohibited conduct. Go back to the burglary. Entering the home is the general intent, right? So you have to focus on that they intentionally engaged in the conduct that led them into the home, right? But the specific intent is going to be that intended result, which is committing a felony once they're inside. Rape, robbery, kidnapping, whatever. You have to be able to prove that result, happens. Now, constructive intent, this exists when the law treats conduct as intentional because harmful consequences are so likely that that intent is basically, effectively implied. All right, so imagine if you have someone who's firing a gun into a crowded room just because they want to scare people. Well, they can later come back and claim, well, I didn't actually intend to kill anybody, but criminal law can still treat that conduct as intentional because death or serious injury at least is something that's so foreseeable when you're shooting a gun, especially into a crowded room where there are people. Okay. So that's one reason why criminal law often allows intent to be inferred from the circumstances. So the actions themselves can strongly suggest intent. And honestly, juries do kind of evaluate that constantly. Again, people rarely confess their internal thought process directly. So intent is going to be proven through behavior and statements and planning and concealment and circumstances and even foreseeable consequences. This is the slide that always makes me think of Legally Blonde. So criminal law distinguishes between malum in se and malum prohibitum offenses. And if you've watched Legally Blonde, you know exactly what I'm talking about. So malum in se, it means that it's wrong in itself. Malum prohibitum means that it's wrong because it's prohibited. Okay. So malum in se crimes are going to be considered crimes that are inherently evil: murder, rape, robbery, arson, those types of things. Okay. They are generally viewed as morally wrong regardless of the legal system. Society condemns them. And honestly, those crimes usually require, stronger proof of wrongful intent because they involve, very serious moral blameworthiness. Now, malum prohibitum offenses are different. These acts are criminal primarily because legislatures prohibited them. All right, so that would be like a licensing violation or a tax violation or a regulatory offense or some sort of like administrative infraction. All right, now it doesn't mean that malum prohibitum offenses are not, that they're unimportant or anything like that, because some of those regulatory crimes do things like protect, public health and environmental safety and our financial systems and public welfare. But morally, society often views them differently than inherently, violent crimes. And honestly, that distinction, kind of influences public perception constantly, where people will react differently to, say, serial murder versus someone, just failing to like file proper paperwork. Even though both technically violate criminal statutes, they still look at it differently. You even have a whole section of people out there who look at Luigi Mangione as kind of a hybrid of this as well. They're like, oh, well, yeah, he killed somebody, but he killed somebody who was over the healthcare system. So we're so anti-healthcare system in the way they treat people that it's okay. Anyhow, just thought I would throw that in there. Now, I think one of the most interesting criminal law concepts involving intent is transferred intent, which, if you've taken towards you've heard this as well. So, transferred intent applies when someone intends to harm one person, but they accidentally harm someone else instead. All right. So that law allows for the transfer of the original intent, the original criminal intent, from the intended target to the actual victim. So, for example, if someone fires a gun intending to kill person A, but that bullet misses, A entirely and strikes B, who's standing right next to them, well, the defendant can still be held criminally liable for the harm that was caused to person B because that original intent to commit violence transfers. Okay. And I know you might be thinking, but they didn't mean to harm that person specifically. And that is true. But criminal law focuses generally on the fact that the defendant intentionally engaged in that dangerous criminal conduct. So the unintended victim does not erase that wrongful original intent, okay? And the transferred intent does have its limits. So like the actual harm generally has to be similar to the intended harm. So if someone intends like minor property damage, but because let's say that there was some sort of unforeseeable catastrophic event that was far beyond like the original conduct, the courts can carefully kind of analyze whether or not transferred intent appropriately applies. All right. The doctrine also generally does, it can't increase liability beyond what the original intent was support. And so that's one of the reasons that, transferred intent exists, is because otherwise individuals could escape liability simply because their criminal conduct harmed, the wrong victim and accidentally, quote unquote, accidentally. And honestly, criminal law tries to avoid rewarding dangerous behavior simply because events unfolded differently than was intended. Okay. Transferred intent, though, often occurs in things like shootings, assaults, arson cases, sometimes where there's, reckless violence. And those cases, they kind of become emotionally complicated because the unintended victims often suffer very devastating consequences despite actually never being the intended target. Now, strict liability operates very differently from most crimes that we have talked about so far. And that's because strict liability crimes do not require proof of mens rea. That means that criminal liability may exist even without criminal intent. All right. So in strict liability offenses, simply committing the prohibited act itself is enough for conviction. All right. And I know that this is a concept that a lot of people find kind of frustrating at first because it really does seem inconsistent with like that traditional idea that criminal punishment should require the guilty mind. But historically, criminal law has very strongly, emphasized things like evil intent plus the evil act, right? Strict liability departs from that. Now, strict liability offenses are often associated with things like regulatory offenses, health and safety laws, public welfare regulations, and certain, minor infractions. So, like selling alcohol to minors, or food safety violations, or certain traffic violations. And the one that, I always use as an example, statutory rape laws in most jurisdictions. Okay. Let's pause on that last example because it really does illustrate why strict liability becomes controversial. Suppose you have an adult who genuinely believes a minor is over the legal age because maybe the minor lied or they presented a fake ID and they appeared older. In some jurisdictions, criminal liability will still be able to exist regardless of that mistaken belief, right? And this is one of those things that we often talk about, like, is that even fair? Does that feel fair? And honestly, fairness concerns are one reason that strict liability crimes remain controversial. You have supporters who will argue that strict liability encourages extreme caution in areas affecting public safety. But then you have critics who argue that punishment without any kind of meaningful intent can produce unjust outcomes. All right. So now strict liability, again, it generally appears more in like regulatory offenses and public welfare statutes and, like lower level crimes that are punishable by fines. But courts have become more skeptical of, severe strict liability offenses that involve, harsh penalties because criminal punishment does traditionally carry moral condemnation. And many judges become uncomfortable imposing serious criminal penalties where intent plays no role whatsoever. So another major exception to the traditional mens rea requirements involves vicarious liability. And this is something that we have started seeing a lot more of. Vicarious liability means that one party can be held legally responsible for the actions of another because of a specific legal relationship. Okay. And this is one concept that does surprise a lot of individuals because liability can exist even where the defendant doesn't personally commit an act or they lacked criminal intent or they weren't like directly involved in the conduct itself. All right. So one common example involves like an employer and employee relationship. So corporations can be held liable for actions that are committed by employees who are acting within the scope of their employment. So like if you have a corporate executive who pressures employees to ignore, say, environmental regulations because they want to increase their profits. If the employee commits regulatory violations while carrying out, company objectives, then the corporation itself can face, criminal and civil liability. Now, corporations obviously cannot be thrown in prison or anything like that, but penalties will, involve things like fines and sanctions, injunctions, probationary oversight, and operational restrictions. But corporate criminal liability became increasingly important as corporations have grown larger and more influential. And without vicarious liability principles, corporations would potentially be able to avoid any kind of responsibility by blaming misconduct entirely on lower level employees. And then again, you might have some who say, is it fair to punish, the corporation for the actions of the individuals? And that is a huge debate, because you have supporters who will argue that corporations benefit financially from employee conduct and they should therefore bear responsibility, right? But then you have critics who argue that liability sometimes punishes organizations kind of broadly for actions that are committed by only a few individuals. Okay, so criminal law is supposed to be constantly balancing accountability and fairness and deterrence and public protection. And I just completely forgot. Speaking of vicarious liability, also think about the parents whose kids have become school shooters, who have been held responsible for the deeds of those children. We have one here in Georgia that has been going through the process. That's an example of vicarious liability. So, modern criminal law often relies heavily on the mental state framework that was developed through the Model Penal Code. And it identifies four primary mental states. You have purposeful, knowing, reckless, and negligent. Okay. And those distinctions become foundational throughout criminal law analysis because the defendant's mental state often determines whether or not criminal liability exists, how serious the offense becomes, and what punishment can apply, right? So let's talk about them individually. A purposeful mental state means that the defendant consciously desired a particular result. And that most closely resembles specific intent. So, for example, if someone plants a bomb intending to kill a specific target, the harmful outcome is the defendant's conscious objective. All right. Knowing conduct, slightly different. A defendant acts knowingly when they're aware that their conduct will almost certainly produce a particular result if that result is not necessarily their ultimate goal. So, for example, if someone burns down a building for insurance money while, they're fully aware that people are trapped inside, their primary goal might be financial gain rather than homicide, but they knowingly created, a deadly situation that has deadly consequences. Recklessness involves conscious disregard of substantial risk. And that becomes important because reckless individuals recognize danger, but they keep going. All right. So, for example, if someone is driving while extremely intoxicated and they're doing it at very high speeds and they're going through crowded streets, they may not specifically intend harm, but they consciously disregard those obvious risks. All right. Negligence involves failing to recognize risk that a reasonable person should have recognized. Okay, so notice the difference there. Recklessness involves awareness and disregard. Negligence involves failure to perceive the risk appropriately. So, for example, you have a parent who leaves a loaded firearm accessible to children. All right, even if no harm was intended, criminal negligence can still exist because the risk should have been obvious to a reasonable person. All right. And honestly, these distinctions, they do become really incredibly important because criminal law, kind of carefully categorizes the level of culpability. And the law generally punishes intentional conduct more severely than negligent conduct. And again, it goes back to that moral blameworthiness spot and how much it differs. One of the most important concepts in criminal law is element analysis. And it's because every crime contains specific elements that the prosecution has to prove beyond a reasonable doubt. Again, it is more than did the defendant do it, okay? Prosecutors have to establish each required component of the offense individually. So, for example, if you have a theft statute that requires proof that the defendant took the property belonged to another, the taking occurred without consent, and the defendant intended to permanently deprive the person, they would have to show all four things. Okay. So if a prosecutor fails to prove even one element, then criminal liability can fail. All right. Intent elements are often among the hardest to prove because mental state exists internally. So jurors can't literally see inside of someone's mind. And that's why we have to rely on the totality of the circumstances, the behavior, the statements, the planning, the concealment, the foreseeability. All of those things are used to establish intent indirectly. And that's one reason that criminal trials often involve very extensive arguments regarding what the defendant intended, that they knew, that they believed, or that they reasonably should have understood. I would say one of the most difficult challenges in criminal law is about proving intent. Because again, intent exists inside of someone's mind. So judges and juries, they can't literally observe those thoughts directly. So the legal system developed different approaches for analyzing intent. One of those is subjective intent, okay? Subjective intent focuses on the defendant's actual state of mind at the time of the conduct. So that's going to include things like their motive, their desire, their goals, their personal understanding. So for example, if you have someone who carefully researches, say, poisons online, or they purchase the toxic substances and then they write threatening messages and then they go and they administer the poison, well, those surrounding facts strongly suggest that there was subjective intent to cause harm. Now, subjective intent can be difficult because, again, defendants rarely openly admit criminal purpose. They don't go around going, I absolutely intended to commit this crime. So that's why prosecutors have to rely on circumstantial evidence. And circumstantial evidence is indirect evidence that allows jurors to infer, conclusions from surrounding facts. And circumstantial evidence can be extremely powerful. It can show things like the planning behavior and if there's attempts to conceal evidence, or did they provide false statements? Did they flee the scene? Did they get rid of some text messages or emails? Were there any kind of prior threats? Things like that. All of that can be used to help establish that criminal intent indirectly. Now, objective intent works differently. It focuses less on what the defendant actually thought and more on what the reasonable person should have known under the circumstances. Okay, this is where we get our reasonable person standard, or our reasonably prudent person standard. All right, so the reasonable person standard asks, how would an ordinary, reasonable person, how would they behave or understand this situation? Okay, so if you have somebody who has a toddler locked in a car alone, it's extremely hot outside on a summer day. All right, defendant can claim, I didn't think anything bad would happen, right? But criminal negligence may still exist because the reasonable person should recognize that obvious risk that's involved. All right. Now, objective standards exist partly because relying entirely on subjective claims would make criminal liability extremely difficult. All right. Otherwise, defendants could just simply claim, I didn't know, or I didn't think, or I didn't realize the danger. So the legal system, therefore, sometimes imposes objective kind of expectations regarding reasonable conduct. And honestly, a lot of criminal law disputes involve tension between what the defendant personally believed and what society reasonably expects for someone to actually understand. Now, because the intent is difficult to prove directly, criminal law does focus sometimes on inferences and presumptions. So an inference is a logical conclusion that is drawn from surrounding facts. Okay, so let's say that you have someone who wears a mask and they carry burglary tools and they entered into a jewelry store at 2 a.m. and they attempt to pry open the display cases. Well, a jury can reasonably infer criminal intent from those surrounding circumstances. Now, again, notice that no one can literally see the intent, but the behavior strongly suggests the purpose. All right. And again, criminal law relies heavily on these kinds of logical conclusions because human intent is usually proven indirectly. Now, presumptions are slightly different. A presumption involves a legal conclusion that courts may require unless it's disproven. Okay. So some presumptions are what's called a rebuttal presumption, meaning that defendants can present evidence challenging them. So, for example, the law may presume that someone intends the natural and probable causes of their actions. So if someone points a loaded firearm at someone and fires, then jurors may presume intent to cause harm unless evidence suggests otherwise. All right. But courts have to be careful with presumptions because criminal defendants still have their constitutional protections, including their presumption of innocence, their due process, and then also the prosecution's burden to prove guilt beyond a reasonable doubt. So improper presumptions risk shifting that burden unfairly onto defendants. Okay. And, we have the whole balancing of evidentiary efficiency against that constitutional fairness that becomes a recurring issue throughout a criminal case. Now, I already said it. Motive and intent, they're not the same thing. All right. Motive refers to why someone acts. Intent refers to what mental state came with that act. Okay. For example, someone kills another person for financial gain. The financial gain is the motive. All right. The intent, or the intentional decision rather, to commit the killing, that is your actual intent. All right. So motive can absolutely influence investigations because investigators ask things like who benefits, who had a reason, who possessed, any kind of animosity, who stood to gain financially. Motive can help explain behavior and kind of strengthen that circumstantial evidence, but motive itself is generally not an element that prosecutors must prove. All right. And remember, going back to that elemental analysis, we have to go by what is in that. And that's why motive is not typically listed. And I know that this surprises a lot of people because, movies and TV shows that are crime related, they focus heavily on motive, right? But legally, someone can commit an intentional crime even where motive remains unclear. So like a person can commit a violent act without investigators ever understanding why, motive alone is essentially not enough though for a conviction. That's the bottom line. Simply having a reason to commit a crime doesn't prove that somebody actually committed it. Okay, and that distinction becomes extremely important because the court of public opinion often confuses suspicion with proof. All right, so people may appear suspicious because they had motive, but criminal convictions require that beyond a reasonable doubt. Okay, but motive is very important during sentencing. Judges and juries can consider motives when, evaluating things like moral blameworthiness. Like, was it a crime that was motivated by greed? Was it racial hatred? Was it revenge? Was it an abuse of trust? Things like that. And they can be viewed more harshly than crimes like of desperation or coercion or like emotional instability. But again, criminal law is going to constantly evaluate both the conduct and the human behavior. Now I have to shift to the second essential element, which is actus reus. So if mens rea refers to the guilty mind, then the actus reus refers to the guilty act. So the actus reus is the physical component of the criminal conduct, all right? Now, one of the most important things that you need to understand is that criminal law generally requires voluntary action, Okay, so in other words, the act has to come from a conscious choice. All right, and that's important because criminal law usually does not punish purely involuntary behavior. All right, so that would be like your reflexes, seizures, unconscious movements, actions during sleep, movements under hypnosis, things like that. So if you have someone who experiences, say, an unexpected seizure while driving and causes an accident, all right, if they had no warning signs and no reason to anticipate the seizure, then criminal liability becomes much more difficult because that conduct was not truly voluntary. But if you have someone who has a known seizure disorder, who ignores like medical restrictions and drives recklessly despite repeated warnings, well, at that point, voluntariness and foreseeability become much more legally complicated. All right. And criminal law focuses, often more heavily on whether or not the defendant exercised a conscious choice or not. Another important principle involves thoughts alone. So criminal law does not generally punish thoughts by themselves. So you cannot be prosecuted simply for hating somebody or fantasies or immoral ideas or even disturbing thoughts, right? This principle is very important because the Constitution protects broad freedom of thought and expression. And of course, there are obvious limits like true threats and conspiracies and solicitation and, criminal planning, things like that. But generally speaking, thoughts alone are not criminal acts, okay? And honestly, that distinction matters so much because governments punishing thoughts rather than conduct creates enormous constitutional dangers. Now, another important issue involving actus reus is whether a person can be punished simply for their status or, rather than their conduct. So generally speaking, criminal law punishes acts and not identity. And that's an incredibly important constitutional principle. For example, a person cannot be criminalized simply because they are ill or poor or addicted or mentally ill, homeless, or part of a protected class. And I know that this brings up a whole new debate, but let's just go with the way the law is supposed to work on a pure basis. Because historically that was a major constitutional issue because governments at various points attempted to criminalize status rather than the conduct, okay? Obviously, conduct connected to status can still be criminal. So like a person cannot be punished merely for addiction itself, but criminal conduct related to drug possession or distribution can create liability. And that distinction matters because criminal law generally requires behavior rather than identity alone. Okay? So this principle connects deeply to constitutional concerns that involve things like due process and fairness and equal protection and even governmental abuse of power. All right. Now, another major issue is possession. All right. So possession crimes are extremely common within criminal law. So that's going to be like possession of, unlawful firearms, stolen property, illegal drugs, child exploitation materials, counterfeit items, illegal weapons, things like that, right? These might seem simple too, like, oh, well, if the item's there, then the person obviously possessed it. But possession can actually become a lot more complicated as well. So one major issue involves knowledge. So suppose that illegal drugs are found inside of a vehicle where there's multiple passengers. Who actually possessed the drugs? Did everybody know that they existed? Did only one person know? Did someone place them there secretly? Right? So there's all kinds of questions. So criminal law now distinguishes between actual possession and constructive possession. So actual possession means that the item is physically on the person. All right, so like drugs in somebody's pocket or a weapon in somebody's hand or like stolen property in somebody's, purse or backpack, right? Constructive possession exists when someone exercises control over an area that has the illegal item, even if that item is not physically on them. So, like, if you have somebody who has, say, illegal drugs, right, and they were hidden inside of their bedroom, then that can support constructive possession arguments because the individual exercises control over that space. All right. Now, cases like this, they become especially complicated when you do have multiple people who share access to the same areas, like shared apartments and shared vehicles or dorm rooms, family homes, workplaces, all of those things. And possession cases often become battles over, knowledge. Who had it, right? Access. Who had it? Control. Again, who had it? And then the intent. But the prosecution generally just has to establish more than simple proximity. So just being near something illegal does not automatically prove any kind of criminal possession. Now, I think one of the most interesting areas of criminal law is omissions. And I think it's one that also one that surprises people when they find out that criminal liability, can happen, because somebody failed to do something, because an omission means simply it fails to act, right? So it's not necessarily from what somebody did, but it's what they didn't do, right? So generally speaking, criminal law does not it does not impose like any kind of broad legal duties to like rescue strangers or anything like that. And that's really important, especially in tort law. But morally, a lot of people feel obligated to help others in danger. But legally, criminal liability for failing to act usually requires a specific legal duty, right? This creates some very deeply uncomfortable ethical discussions. Okay, so for example, suppose someone sees a stranger drowning but walks away without helping. A lot of people would find that morally disturbing, right? But depending on the jurisdiction and the circumstances, criminal liability is likely not going to exist unless a legal duty was present. All right. Now, legal duties come up in several ways. One is by statute. All right. The other, like by statute, meaning, sorry, I had to sneeze. By statute, meaning like a cop or a firefighter, things like that. Those are by statute. They have a liability to assist those in danger. Some jurisdictions do impose legal obligations requiring assistance, and this is where it would be under might be under specific circumstances, okay, but you can also have it through relationships. So like parents generally have a legal duty towards their children, right? Spouses, they can possess legal obligations toward one another in certain situations. You have guardians and caregivers who, also possess duties involving, protection and care. Those relationship-based duties become extremely important in criminal neglect and abuse cases. So, for example, suppose parents intentionally withhold food or medical treatment from a child that results in some sort of serious harm. Well, criminal liability can arise not because of some sort of affirmative violent act, because of the failure to fulfill a legal duty instead. Okay? Another source of legal duty involves contracts. So like physicians, they owe a duty to their patients. Nursing homes owe a duty to their residents. Lifeguards owe a duty to the swimmers that they're responsible for supervising. So failure to fulfill those duties can create criminal liability under certain circumstances. Now, another important category is the assumption of duty. All right. So if someone voluntarily undertakes the responsibility for caring for another person and then abandons them in a dangerous situation, that's a problem, right? Because criminal liability can arise because the individual assumed responsibility and others relied on that assumption. Okay. So, for example, that drowning person, if you go and you try to, you jump in and you go and start pulling that person to shore, and you're like, oh, I can't do it anymore. I'm too tired. I'm going to leave them right here on this log and maybe somebody else will come rescue them. Well, anybody who swims, they might have already left because they were like, oh, somebody's got it. They assumed that it was all handled. But you've now created a liability situation because you have, taken it upon yourself to help the person. And then you have your liability when you create the danger yourself. So let's say that there is someone who accidentally causes a very serious car accident. So even if the original accident was just an accident, the individual still has a duty afterwards, remaining at the scene, seeking help if they can, assist an injured person, things like that. If you hit somebody like on a bike or something, can't just leave them in the roadway. You have to help them, be safe until help can get there. Okay. So hopefully that kind of gives you an idea of those. But omission cases, they often become very morally difficult because they do force society to come to a decision of when should failure to act become criminal. And you got to step out of that moral zone. Now, let's talk about causation because it asks whether or not the defendant's conduct actually caused the prohibited result. Okay. And honestly, this becomes much more complicated than you might initially expect, right? Because criminal law requires two forms of causation. We have the actual causation and the legal causation. Factual cause is often called the but-for causation. In other words, but for the defendant's conduct, would the harm have occurred? Okay. So if someone shoots another person and the victim dies immediately from that gunshot wound, but for the shooting, the death would not have occurred. Okay. Very simple test to do there. Now, the legal cause is also called proximate causation, and it becomes more complicated because legal cause asks whether or not the resulting harm was sufficiently connected and foreseeable, so much so that criminal liability is appropriate. All right. And foreseeability becomes really important here. Okay. So, if someone assaults another person, causing very minor injuries, right? And then while the person is being transported to the hospital, the ambulance is struck by lightning and now the person's dead. Okay. Well, at some point, you have this extraordinary intervening event that can break that chain of causation, right? That is the concept of an intervening cause, which is an event that occurs after the defendant's conduct that can reduce or eliminate that criminal liability, but only if it becomes sufficiently independent or unforeseeable. Okay, so courts are going to ask, was the result foreseeable? Was it the natural consequence of the conduct? Did another event supersede the defendant's actions? That type of stuff, right? So causation cases can become incredibly complicated because life itself is complicated. So human events, they rarely unfold in perfectly clean sequences, right? So proximate cause is especially important when it comes to homicide cases. So if you inflict injuries on another person who later dies after they get some sort of, negligent medical treatment, well, then the question becomes, should the original attacker remain criminally responsible? And in a lot of situations, the answer is yes, because medical complications can still be considered foreseeable consequences of the original violence. All right. But causation analysis is going to rely heavily on foreseeability, timing, were there any intervening events, and the relationship between the conduct and the outcome. All right, so now that we've discussed mens rea and actus reus separately, we need to connect them together through concurrence. This means that the guilty mind and the guilty act have to occur together. So in other words, the criminal intent has to accompany the criminal conduct. And that might sound obvious at first, but concurrence issues can become a little complicated. For example, suppose that you have someone who accidentally takes, say, a very expensive coat from a restaurant believing that it's theirs, right? At the moment they picked up the coat, that criminal intent didn't exist. but later they realize, oof, this is not actually mine. But they say, you know what? I'm going to keep this. Well, now criminal liability becomes complicated because the act occurred accidentally, but the intent developed afterwards. So the timing between the intent and the conduct matter. Criminal law generally requires that the mental state has to exist during the criminal act itself. All right. But that creates a whole, set of issues. And we'll get further into that as we go through. Concurrence also connects to the attendant circumstances. And these are just additional facts that have to be proven along with the mens rea and the actus reus. So going back to somebody taking that property they believe belonged to them. Even if the physical act occurred intentionally because they intended to take the coat, but they believed that it was theirs, that's where criminal liability can fail if they honestly lack the knowledge that the property belonged to someone else. Okay? And you have other things too, like age and location, relationship status, ownership, legal classification. These can all become important attendant circumstances depending on the offense. And criminal law is constantly combining, these things with like the physical conduct and the mental state into one of a more larger legal analysis. But the attendant circumstances are going to be the things that are going to either basically, are they going to mitigate the situation or are they going to aggravate it? For example, age can become a factor if the person, who says they were raped is under a certain age, then that can become an aggravating factor. And that attendant circumstance of age is going to cause that to move. Hopefully that explains it. All right, now this is our last slide. We do need to talk about ethics because honestly, the concepts, discussed today are not just technical legal concepts. They, do involve real human beings and real liberty interests and enormous governmental power, right? So the mens rea and the actus reus are not simply like these academic vocabulary words that, lawyers have to memorize for exams. These concepts, they determine, who society punishes and how severely people are punished and whether criminal liability is morally justified in the first place. So ethical concerns become especially important when we start thinking about intent because proving intent is so complicated. Again, jurors cannot look into someone's mind and see their thoughts, right? Investigators cannot open someone's mind and subjectively measure the motives or the mental states or anything else, right? So criminal justice systems rely heavily on interpretation and inference and assumption and witness credibility and circumstantial evidence and, more importantly, human judgment. And let's be honest, human judgment is imperfect, right? So this creates ethical responsibilities for law enforcement, prosecutors, judges, defense attorneys, forensic experts, jurors, all the people involved, right? So if you have investigators who become emotionally convinced that someone is guilty early in an investigation, that belief can unconsciously shape how the evidence is interpreted, which suspects are going to receive attention. You have like what witnesses are going to appear credible, what facts are even emphasized or minimized. And that's referred to as confirmation bias. And confirmation bias occurs when people interpret information in ways confirming the beliefs that they already hold. All right. So confirmation bias can become extremely dangerous within a criminal investigation because once investigators become convinced that they, quote unquote, know who committed a crime, they may unintentionally overlook contradictory evidence. And that's one of the reasons that ethical obligations matter so much. So law enforcement officers have ethical duties involving, honesty and constitutional compliance and accurate reporting and proper evidence handling and fair investigative practices, right? In the same vein, prosecutors, they have their own ethical responsibilities. So one thing I want to say is that I know sometimes people understand, they misunderstand rather the prosecutor's role. They're not ethically supposed to pursue convictions at all costs, right? Their ethical duty is to seek justice. And honestly, those aren't always the same thing. So if you have a prosecutor who hides exculpatory evidence, they may technically increase the likelihood of conviction while simultaneously violating constitutional and ethical obligations. Again, remember that exculpatory evidence refers to evidence that's favorable to the accused. Under Brady v. Maryland, prosecutors are constitutionally required to disclose exculpatory evidence to the defense, and failure to disclose violates due process. And again, I cannot stress enough that there are numerous wrongful conviction cases throughout American history that involve suppressed evidence and coerced confessions and mistaken eyewitness identification, unreliable forensic testimony, and even unethical investigative conduct. Okay? Defense attorneys, they also have their own ethical challenges. They are ethically obligated to zealously represent clients within the bounds of law. That means that they can challenge evidence, they can question police conduct, they can dispute witness credibility, they can attack forensic reliability, and they can force prosecutors to meet constitutional burdens of proof. All right? Now, sometimes when we start working on cases, we emotionally struggle with the idea of these types of situations, like particularly if you're working in defense, right? Again, the whole concept of how can they sleep at night? How can they, represent these people? How can they defend somebody who is obviously so guilty? But remember that question misunderstands the purpose of constitutional criminal defense. All right. Defense attorneys are not responsible for determining guilt. That is the responsibility of the legal system itself. It is their job to ensure that constitutional rights are protected, that governmental power remains limited, and that prosecutions satisfy legal standards. All right. And honestly, effective defense advocacy protects, again, everybody's rights, including innocent people wrongfully accused. When it comes to the strict liability offenses, remember that those crimes, they impose punishment without requiring proof of criminal intent. And that raises some questions as well. Like, is it fair to impose criminal punishment where intent is absent, where knowledge was missing, or where harm was accidental? Reasonable people disagree strongly about these questions, but supporters will argue that strict liability protects public safety by encouraging extreme caution. But then you've got the critics who argue that punishment without any kind of meaningful culpability undermines moral fairness. Okay? And again, that tension continues to exist throughout the criminal law period. So I can't stress enough, the legal system is supposed to be constantly attempting to balance fairness and accountability and public protection and constitutional liberty and moral blameworthiness. Okay? The last thing that I wanted to add is overcriminalization, because modern legal systems contain enormous amounts of criminal statutes and regulations. And critics argue that society increasingly criminalizes conduct that might be better handled civilly, or that involves regulatory complexity, or it might lack some sort of meaningful moral blameworthiness, right? But others argue that criminal enforcement remains necessary because we have to protect public safety. We have to regulate harmful conduct, and we have to maintain social order. So again, criminal law constantly reflects larger societal debates involving, morality and politics and fairness and even governmental power. All right. And honestly, one of the most important things that I want you to remember moving forward is this, and that is that criminal law is never just about statutes. It's about people. It's about liberty and constitutional rights and trauma and fear and accountability and power and justice. And because those stakes are high, the ethical responsibilities within criminal justice do become really incredibly important. All right. So I'm going to get off my soapbox now, but I just want you to recognize that mens rea and actus reus, they do form the foundation of nearly everything that we're going to discuss moving forward. So nearly every criminal law issue is going to come back to questions involving intent and conduct and causation, voluntariness, and culpability. So again, this chapter, it demonstrates something extremely important about criminal law, and that is that the system generally does not punish people simply because bad things happen. Criminal law carefully is supposed to carefully analyze what happened, why it happened, what risk existed, what the defendant intended, and whether criminal blameworthiness truly exists. Now, obviously, criminal law does not always reach perfect outcomes. And the reality is that human systems never do. But understanding those foundational principles can at least help explain why criminal law often treats some very seemingly similar situations very differently. And again, because in criminal law, intent matters, context matters, conduct matters, and circumstances matter. And throughout the rest of this course, we're going to continue building on those principles as we move deeper into, homicide and inchoate crimes and, defenses and constitutional procedure and even criminal responsibility. Let me know if you need anything. Bye.